On September 3, 2009, a 23-year-old man named Daniel Pruitt walked into a police station in rural Georgia and confessed to a murder. He described the scene, he knew details, he signed the statement. The case was closed in 11 days. There is only one problem with that confession. Daniel Pruitt did not commit that murder. And buried in the original case file, a file that sat untouched for 6 years, was the proof. Welcome back to Cold Frequency. This is the channel where we follow the signal even when the system decided it was easier to ignore it. Today's case is different from the last two. We're not looking for a missing person, we're looking at a conviction and at the question of how an innocent man ends up signing a confession to a crime he didn't commit. Stay until the end, because the person who actually committed this crime was known to investigators from the very beginning. On the night of August 29, 2009, a 44-year-old man named Raymond Holt was found dead in his home in Clover Falls, Georgia. Cause of death: blunt force trauma. The house showed no signs of forced entry. His wallet and car were untouched. Investigators initially focused on two people: Raymond's estranged brother Victor, with whom he had an ongoing property dispute, and a former employee named Marcus Webb, who had been terminated 3 weeks earlier under disputed circumstances. 5 days into the investigation, both men had been interviewed and released. The trail was going cold. Then Daniel Pruitt walked in. Daniel was 23. He had a prior conviction for petty theft and had known Raymond Holt casually. He'd done odd jobs at the property the previous summer. He told investigators he'd been drinking, that he'd gone to Raymond's house to ask for money, that things had escalated. He knew which room, he knew the approximate time, he described a specific object. The interrogation lasted 9 hours. Daniel had no lawyer present for the first 6. He signed the confession at 2:14 a.m. Daniel Pruitt went to trial in February 2010. His public defender argued the confession was coerced. The jury deliberated for 3 hours. Guilty, sentenced to 22 years. Here is what the jury did not hear. First, Daniel's fingerprints were not found at the scene. The prosecution argued he'd worn gloves. No gloves were ever recovered. Second, the object Daniel described in his confession did not match the actual murder weapon. The defense raised this. The prosecution argued he may have been confused about the specific item after the fact. The judge allowed the confession to stand. Third, and this is the detail that stopped me when I first read this case, a neighbor had reported seeing a dark pickup truck parked outside Raymond Holt's house the night of the murder. She gave a partial plate. That report was logged. Daniel Pruitt did not own a vehicle. The truck was never traced. The neighbor's statement was not presented to the jury. In 2015, a newly appointed county prosecutor reviewing old cases as part of a conviction integrity initiative pulled Daniel's file. What she found in that file had never been disclosed to the defense. The partial plate from the neighbor's report, the one that was logged and then set aside, matched a vehicle registered to Marcus Webb, the former employee, the man who had been interviewed and released 5 days before Daniel walked in. There was more. A second witness, a teenager who was walking home the night of the murder, had told officers he saw a man leaving Raymond's property around the estimated time of death. His description did not match Daniel Pruitt. His statement was in the file. It had never been shared. This is a Brady violation. Under American law, prosecutors are required to disclose evidence that could be favorable to the defendant. Both pieces of evidence, the plate match and the witness statement, should have been handed to the defense before trial. They were not. Daniel Pruitt's conviction was overturned in 2016. He had served 6 years. Marcus Webb was brought back in for questioning. He declined to speak without an attorney. He has not been charged. The original prosecutor who withheld the evidence retired in 2013. No disciplinary action was ever taken. The murder of Raymond Holt remains officially unsolved. I want to be precise about what that means. A man confessed under 9 hours of interrogation without a lawyer for 6 of them to a crime he didn't commit. Evidence pointing to another suspect was withheld from his defense. He served 6 years. The person who likely withheld that evidence faced no consequences for failing him, and the man who may have actually committed this murder has never been charged. Every part of that sequence is a choice the system made. Daniel Pruitt was released in 2016. He was 29 years old. He had entered the system at 23. He has spoken publicly about the interrogation only once in a brief interview 2 years after his release. He said, and I'll paraphrase here, that after enough hours in that room, you start to believe that signing the paper is the only way out, that the truth becomes less real than the pressure. False confessions account for approximately 29% of wrongful convictions overturned by DNA evidence in the United States, according to the Innocence Project. Daniel's case had no DNA component. It was a paper trail and a witness statement that finally cracked it open. I want to know what you think. Not about Daniel's guilt, that question has been answered. About accountability. About what justice means when the system that failed him faces no consequences for failing him. Leave that in the comments. I'll be reading. If Cold Frequency is the kind of channel you want more of, subscribe. Next week, we follow a pattern 3 investigators missed, 3 victims, 3 different states, 1 connection nobody looked for.